there are issues with the constitutionality of the bill. Government is claiming that the bills are constitutional, and the protesters and the persons, other public who are supporting the protesters are saying that farms bill are unconstitutional. So let's start from the point whether the farms bill are constitutional or not. So moving on to the first slide. Now we are going to check the constitutionality of the bill. So the constitutionality of any bill passed by the either by the president or by the parliament can be checked by checking the content of the bill or by checking the procedure of the bill. The procedure of the bill by which the bill was passed. Now, now let's discuss the content of the bill. So the bill has the content related to agriculture, and under it, what agriculture? Under it, production, supply, distribution, trade, commerce, and agriculture services. It has all the content related to agriculture, and for agriculture, production, supply, distribution, trade, commerce, and its services. Now, for checking the content of any bill, we have to check in two parts. The first part is to check that whether the bill passed is against the fundamental right, which is provided in part 3 of the constitution, or secondary, is the bill passed is against the basic structure of constitution or not. So it's very clear that bill is not against the fundamental right, because the bill only has the content regarding the agriculture and its production, supply, distribution, trade, and commerce. Now, coming to the second point, that whether the bill is against the basic structure of constitution. So before discussing the second point, we should know what is the basic structure of constitution. So basic structure of constitution is a theory, is a doctrine which evolved in Keshwananda Bharti case. There is a famous landmark case of Keshwananda Bharti case, known as Keshwananda Bharti case. And in this case, the court held by a margin of 7/6 that although no part of the constitution, including fundamental rights, was beyond the amending power of parliament, the basic structure of the constitution could not be abrogated even by a constitutional amendment. Means the Supreme Court wants to focus that though no part of the constitution, none of the articles of the constitution is very easy to be amended, but then also they can be amended. But then also there exists a basic structure of the constitution. Basic structure has certain characteristics of the constitution which can't be abrogated nor can be amended. So moving on to the point, what is the basic structure? Means what are the characteristics of the constitution which comes in the basic structure? As we have now we know that basic structure is evolved in the Keshwananda Bharti case. This is a doctrine and evolved in the Keshwananda Bharti case. Now coming to the point, the characteristic of constitution which are there in the basic structure. So uh, Supreme Courts at various instances have given some characteristics which are part of the basic structure and can't be amended. Some characteristics are the supremacy of the constitution, secular character of the constitution, sovereignty of the country, separation of power, and federal character of the constitution. There are others also, because Supreme Court not only at one instance but at different instances have given different characteristics of the constitution which comes in the basic structure. So these are the characteristics which are basic structure and can't be amended. One of the characteristics from all of them is federal character of constitution. Now moving to the second part. Now federal character of constitution can be also termed as federalism. uh, Protesters are claiming that the bill is against federalism, against the federal character of constitution. And point to be noted that if the bill is against federal character of constitution, then the bill is violative of content, violative as per the content, because it's against the federalism, which is a part of the basic structure. Now discussing what is federalism. So federalism also is a doctrine, and as per this doctrine, uh, this doctrine mentions that center and state both are independent as per the subjects given to them to make right on the on the subjects prescribed to them. Means explaining it further is that states have got some subject and center have got some other subjects, and both are independent to make laws on the subjects which they both have got separately. And there are some other subjects uh, on which both center and state both can make law, and these subjects are mentioned in the concurrent list. So moving on to the Article 246. Article 246 of Constitution of India mentions three types of list. First list is union list, second list is state list, third is concurrent list. Union list has the subject which are separate from the state list, and it has the subject on which center has the power to make law independently. Now coming to the state list has the subjects on which state has the power to make law independently. For making any law on the subjects which are in the state list, state doesn't have has to ask from center. State can make law independently. Now coming to the concurrent list. Concurrent list have the subject has the subjects on which center and state both can make law. Now, coming to the Article 254. Article 254 states that if there is any inconsistency between laws passed by parliament and those passed by state legislature on the topic mentioned in concurrent list, the former will prevail. So if center is making the law on the subjects which are prescribed in union list, then states will have no problem. And if states are making law which are mentioned in the prescribed in the state list, then center will have no problem. But suppose there is any topic which is mentioned in concurrent list and center and state both has the power to make law, then what will happen? Suppose there is a topic which is mentioned in the concurrent list, and center also makes law on that topic and state also makes law on that topic, and suppose a condition arises that the law made by the center and made by the state both are absolutely inconsistent, both are not matching, both are contradictory to each other, then what will happen? Then as per article 254, article 254 is tilted towards center and suggests that if there is any inconsistency between laws passed by parliament then those passed by state legislature and those passed by state legislature on the topic mentioned in concurrent list, then the former will prevail. Means the law of center will prevail. It doesn't matter state has also made the law on the same topic, but the law of center will prevail. Now moving on to the entry 33 of concurrent list. Entry 33 of concurrent list gives right to central government to make laws on agriculture related to production, supply, distribution, trade, and commerce. Now it's very important to note that agriculture as a topic is also in the state list. Means state also has the power to make laws on agriculture, and center also has the power now because entry 33 of concurrent list gives right to central government to make laws on agriculture. So center also has the power to make laws on agriculture. Now both the party state also and central government also has the power to make law on agriculture as a topic. So if center has made law, then it has done nothing wrong because concurrent list entry 33 of concurrent list gives power to center to make law on the topic agriculture. So we nobody can say that the farms law 2020 are in violation of doctrine of federalism. It's not, because it's very clear that entry 33 of concurrent list has the topic agriculture and the center has the right to mm, to make law on the topic agriculture. Now it's very clear that as per the content is not the issue. Content is not violatory to any constitution article. Now moving on to the procedure, that whether the procedure by which the bill has been passed or the by which the law is passed, whether the procedure is contentious. So moving on to the article 123, because the bills were promulgated as an ordinance on 5th June 2020. So what is ordinance? We have to know what is ordinance. So ordinance is mentioned in article 123 of constitution. By article 123, article 123 gives power to president to promulgate ordinance when parliament is not in session. This ordinance will have the same force uh, as that of an act and shall be laid before both houses of parliament and shall cease to operate at the expiration of 6 weeks from the reassemble of parliament if not passed by both houses of the parliament. So we have to highlight some points in article 123 which are the major points. The first point is that president has the power to promulgate the ordinance as per article 123, but president can exercise this power of promulgating ordinance only when the parliament is not in session. So the first criteria of president promulgating the ordinance is that the parliament should not be in session. First is that. First is this. Now coming to the second. Second part is that the ordinance will have the same force and effect as that of an law. Now, coming to the third point is that when parliament comes in session, then they have to pass that particular ordinance within 6 weeks. They have to pass that particular ordinance within 6 weeks in both the houses. And if it's not passed by both the houses of the parliament, then the that particular ordinance which has the till which has that till time which has the same force and effect as that of an law will cease to operate. Now let's check the condition what government did this time. So the bills were promulgated as an ordinance on 5th June 2020. That time lockdown was going on, so parliament was not in session at 5th June 2020. So it's very clear that the first criteria is fulfilled. Now president has the power to promulgate ordinance as per article 123, and parliament is also not in session. So president can promulgate that particular ordinance which is farms related to farms law. So that ordinance was promulgated on 5th June 2020. And what happened after that? After that, it was passed in Lok Sabha on 17th September 2020, and then in Rajya Sabha on 20th September 2020, which is within the duration, which is within the expiration of 6 weeks from the reassemble of Parliament, because Parliament started this session in September only. So it's very clear that there is no fault in procedure, and procedure is right. It's not in violation to the Constitution. So we have checked the constitutionality of the bill. It's constitutional as per the content, as per the procedure. If anybody have any question, then they can raise the question. I will wait for 1 minute, then we will move further.
No, sir.
Okay. Okay. So moving on to the next slide. Next slide is about the three bills, the name of the official name of the three bills, because everybody is naming three bills as farms law, because they many people don't even know what three bills are. They don't even know the name of three bills, and they are just protesting government. Many people in government also don't know the name of three bills, and they are claiming their own. So the first bill is the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. The second one is the Farmer Empowerment and Protection Agreement of Price Assurance and Farm Services Bill 2020. The third is the Essential Commodities Amendment Act 2020. Now, the major thing is that the first two bills are new, but the third one, the Essential Commodities Amendment Act 2020, as mentioned in the name itself, it's an amendment. It's an amendment of the uh, initial principle, which is the Essential Commodities Act 1955. There was an Essential Commodities Act 1955, which is amended now, and thus named after the amendment, it was named the Essential Commodities Amendment Act 2020. Now, moving on to the first bill. So, coming on to the first bill is the Farmers Produce Trade and Commerce Promotion and Facilitation Act 2020. As the name suggests, what this bill wants to do, this bill wants to promote and facilitate the trade done by farmers. And what kind of trade? The trade of agricultural produces, because farmer does agriculture, it's his profession, and the the bill promotes and facilitates the trade done by farmers. Now, how it will promote? We have to look for the look in the provisions that how is the bill going to promote the trade done by farmers. So the it is the summary of all the provisions, and we will cover each points. So the first point is that the bill facilitate trade areas outside registered mandis. Means earlier what the condition is that it's illegal to sell the first harvest of the farmer outside the mandis, and mandis are named as APMC, which is Agricultural Produce Marketing Committee. Mandis have their own and different name in various states, but they are generally for a common term, for a national term, they are known as APMC, which is Agricultural Produce Marketing Committee. So earlier the condition is that the farmers has to sell his or her first harvest in APMC only. Now, this bill gave other opportunities to the farmer, because this bill provided the farmer, facilitated them in selling their first harvest to other places also. Means other places, the bill has not specified many other places, but has given 2 3 other places, and the farmers now can sell their first harvest at any place. which is like giving them the opportunity, giving them the freedom to sell. Suppose there is a industry which makes pen, and they want to, they can sell that pen at any place in India. So why the farmers are restricted now? Now after the passing of the bill, they can also sell their first harvest outside APMC. And mentioning one more thing about APMC is that APMC is there in each district. Means each district has its own APMC, and the farmer from that district has to sell their crops in that district's APMC only. They can't even sell their crops their first harvest in other district APMC. They have to sell, and they are restricted to that particular district's APMC. Now, coming to the second provision is that uh, this bill has facilitated and given them the opportunity to trade intra-state and interstate. Means they have given this bill has given them the opportunity to trade interstate and interstate. As now we know that farmers have the opportunity by the first provision, by the first point, farmers have the opportunity to sell outside their district's APMC. And if they have the opportunity to sell outside their district's APMC, so now either they can sell in neighboring district, or they can sell in other states district. They can sell anywhere. So now it's very obvious that they have the opportunity to sell intra-state or interstate. Now coming to the third point, they have farmers now have got the opportunity of online trading. This bill mentions that farmer can trade online. So it's very obvious from the first point only that if the farmers are not restricted to sell their crops in APMC, sell their first harvest in APMC, then they can sell it anywhere. Either they can sell, they can, by the means of online trading, they can sell it in intra-state or interstate or outside India also. If it's feasible, then they can sell outside India also by the online means. So this opportunity is provided to the farmers by this bill. Fourth point is that there will be no state taxes. So let's first come to the APMC. What happens in APMC? That is, first, when a farmer move to APMC to sell his first harvest, then there are different kind of tax, 2 to 3 kind of tax in APMC, and it's a loss for the farmer because the taxes are going from farmer's pocket. There is a tax, I am naming it. There is a tax, rural development cess. It goes from the farmer's pocket. So farmers is facing loss at APMC. So that's why government has removed taxes from other other centers. Means if farmer is going to sell crops at any other place than APMC, then there will be no such taxes. So farmer will be in a more beneficiary position to sell at other centers rather than in APMC. Now, coming to the fifth point. Fifth point is a dispute settlement mechanism. Suppose there is a dispute regarding that particular trade. Means suppose farmer went to any other center than APMC. Suppose he went to any other center and wants to sell his crops there, and he sold his crops there. And but the shopkeeper uh, has not provided the total cost to the farmer. Means as the cost was agreed, the farmer has not got the cost agreed. Then what will he do? Then the farmer can apply to the SDM. So now it's very important to know that there is 3 kind of steps which will follow. So first the farmer will apply to the SDM. then sdm will then SDM will make a conciliation board, and in that conciliation board, SDM will appoint one person, one authority, and 2 persons from the shopkeeper side and 2 persons from the farmer's side. So 2 parties and one authority who is going to discuss, and who is going to uh, take the trial and deduce the result. So there will be a conciliation board who will decide the result, and the conciliation board has to submit the report of its decision to the SDM. First step is of conciliation board. Then suppose the decision made, there is a decision which conciliation board has made, and both the one of the party is not agreeing, is not satisfied by that decision. Then they can apply to the SDM. Then the second step starts. In this type of trial, SDM will himself sit in the trial, and he will himself listen to both the parties, and then he himself will come to a particular conclusion, and he will provide his or her decision. Suppose both the parties or any of the parties are not satisfied by the decision of the SDM, then they can apply to the collector. This is the third step of the dispute settlement mechanism, and third and last step. So they can apply to the collector, and then collector will hear both the parties and provide his decision. Then if both the parties have to agree to that particular decision, they have to sign on that particular decision that they are agreeing, because after the collector they don't have any place to apply, because they don't go to courts, can't go to civil courts. These are all the only three steps in which their dispute will be settled. So they can't approach any trial court or any civil court for that particular dispute. Okay, so is there any doubt in this bill, or I move further?
No, sir, no doubt.
Okay, so moving on to the next bill. Next bill is the Farmer Empowerment and Protection Agreement of Price Assurance and Farm Services Bill. So, as the name suggests, this bill is trying to empower the farmers, and at the simultaneously they also want to protect the farmer. This this the name suggests. And how they will protect the farmers, how they will empower the farmer? By having some measures on the price assurance and on the farm services. So how they are going to manage these all things? For this, we have to look in the provision. So moving on to the first point, which is agreement. So government has made it very clear in the bill that there will be an agreement between the farmer and the sponsor for the farm produces or the services. So taking it short, this bill is also known as contact farming bill. So what is contact farming? Suppose there is a factory of Lay's, and they want potatoes in bulk. So what they can do, they either they will go in the market or buy potato from there, but it's not feasible for a factory like Lay's. So what they can do, they can have an agreement with a whole village, or with some farmers, or with the farmers of two or three villages. They can have an agreement, and then the Lay's factory will be sponsor, and the other party is the farmer. And they can have an agreement. In that agreement they will have the period, and they will have the quantity, and they will have the price which which the factory is going to pay to the farmers. So there will be an agreement, so that there will be no loophole after. So coming to the second point is of period. For how much period the agreement can be there? So the minimum time period which the government has prescribed is of one crop season, and the maximum period can be of 5 years. It doesn't matter how many crop seasons are there in 5 years, but the maximum period is of 5 years and the minimum is of one crop season. Now moving on to the third point. Third point is model contract. So it's not mandatory for the government to provide model contracts. Government may provide a model contract or may provide some guidelines. So what happens? The company like Lays have legal advisors. They can frame, because a legal advisor, a person who is well in the legal field and is a legal advisor of a factory, have is well versed than other common people. He knows law much more than other people. So he can frame the contract in such a way that it will be a loss to the farmers. He can frame a contract in such a way that the factory will be in a beneficial position. So the government has mentioned the provision that government can provide a model contract or guidelines. In the model contract, what government can do? Government can write a contract, and then they can provide some spaces there to be filled by the farmer and then the sponsor. So there will be no loophole in the contract itself. Now coming to the fourth point. Fourth point is of price fixing mechanism. So there are many people protesting for the price fixing, that the company will do their own, company will give us low price, company will give us less price than the market itself. So that's why government has provided this price fixing mechanism in the bill itself, in the bill to empower and protect the farmers. So there are two types of price fixing. First is prefix, or second is prefix plus flexibility. Coming to the first type is that prefix. Suppose uh, because the price is decided after the crops come in the market. So suppose there's a company Lays which approaches the farmers and tells all the farmers that we are going to give you 24 rupees per kg of the potato. And the market price of potato that time, suppose it was 18 rupees per kg. So farmers are at a beneficial position. So they will agree. They will agree, okay, we will produce potatoes and you give us 24 rupees per kg. Then what happens? Suppose after the harvest, suppose after a particular crop season and after a harvest, when the time came that Lays company came and started collecting all the potatoes, then suppose that time the market price of potato rises to 35 rupees. But the company has already made an agreement with the farmers that they are only going to give them 24 rupees per kg. Then the farmers will be at a loss. That's why there is an other type of price fixing mechanism also. The other type mentioned prefix plus flexibility, means the Lay's factory at Lay's factory also can fix the price at 24 rupees per kg. But suppose the price increases in the market at the time of harvest, then there should have a opportunity, there should have a flexibility condition added to the agreement, that as per the market, as per the proportion the price has increased in the market, the factory should also increase the price which it has prefixed. So if they are not giving 35 rupees or 36 rupees, then they should fix the price at 34 rupees at the time of harvest if the market price is 34 rupees. Now, coming to the fifth point. Fifth point is delivery and payment mechanism. So first, it's very important to note that in APMC, what happens? Suppose someone is there in APMC, it's a usual practice of APMC that APMC uh, means APMC. What happens that if, when a farmer moves to APMC and sells his or her crop in APMC, then they are not going to get the price for their particular crop instantaneously. They are not going to get it. They are either going to get it in 3 months, 2 months, 1 month. It is always delayed. It's a usual practice of APMC. It doesn't matter of the APMC can be of any state, but the usual practice is that they are going to give the price, they are going to give the money to the farmer, the required money to the farmer in 3 months, 1 month, or 2 months. But this bill has uh, stated clearly that if there is any sponsor, if there is any agreement between the farmer and the sponsor, then the sponsor has to pay for the delivery in within 3 days of delivery. They have prescribed it, and if they have not paid in 3 days of delivery, then there will be a case, and if the factory loses, then they have to also pay the liabilities to the farmers. Now, coming on to the next point, which is farmers land. So in news is a very contentious point. Many of the protesters are saying that company will come, they will acquire their land, they will take land from farmers, so farmer will lose their land. So let's come to the reality. What is the reality of this bill? As per this bill, there can't be, the factory can't acquire any land from the farmer, because the agreement between the farmer and sponsor is of the harvesting crop, is of the crops, not of the land. So they can't acquire land. And also one more thing, the factory also can't raise any permanent structure in the land of farmer. Suppose what happens, a factory came and raised permanent structure in the land of farmer, then the farmer will be at loss, because he has only that much of land. And now if there is any permanent structure, then where the farmer is going to sow the seeds? So it's very clearly mentioned in the bill that the factory can't raise any permanent structure in the farmer's land. And suppose a factory did this by the fraudulent means, suppose a practice did this, or suppose a factory did this, then then the then the factory will be liable to remove that permanent structure. And if the factory is not able to remove that permanent structure, then that permanent structure will be of farmer, will be in the acquisition of farmer. It's very clearly mentioned in this act. And the as if the court decide, then the factory also has to give liabilities to the farmer, because the factory has raised that permanent structure without the permission of the farmer. Now coming to the next point, which is of registration. So it's very simple. Every sponsor has to register with the state government before starting and before coming into any agreement. Now coming to the next condition, which is force majeure. What force majeure states? Force majeure is for every contract. in every contract there is a condition of force majeure. So force majeure states, suppose there is any act of god situation which is termed as act of god, such as earthquake and the pandemic which is going on these days. Suppose these kind of situations are there, then the contracts which are affected by these pandemic and these act of god situations and by the earthquakes becomes null and void. So this is the clause of force majeure, that if there is any act of god situation, then the contract and the agreement made between two parties, which is contract, will become null and void. Now, coming to the dispute settlement is same. The first is of conciliation board, second step is of the SDM, third is of the collector, same as of the previous law. And there is no scope of moving to any civil court, because the collector is the last opportunity and the last person and the last point and the last enter to have the trial. Now, moving to the penalties. So penalties is a very tricky and we have to understand it. So in penalty what happens, that suppose there is a one person who is a farmer, he is alone in his family and has a particular amount of land, and he's having potatoes in that particular land and is in agreement with the leach factory. Suppose that person, due to some illness and due to some accident or due to some any other condition, was unable to uh, produce that much potato which the factory has an agreement with that person. So what will happen, the company is at loss, because the desired result, the company hasn't got the desired result, that much desired potato from that particular person. So in the normal contracts what happens, if the one party is at loss due to the other party has to pay the penalties to the first party, because the first party is at loss due to the irresponsibility of the second party. But in this case, this is not the condition. In this case, if farmer doesn't has to pay any penalty to the leach factory. It had made been very clear, because government thinks that farmers are a very lower strata of the society and they are not so economically feasible to pay penalties to the leach factory. That's why the farmers don't have to pay any penalties, and none of the clauses in the agreement uh, can be added to say that farmers is going to pay penalty if there is any problem. So it's very clear now. So moving on to the last point, which is aggregator. So aggregator and FPO is a farm produce organization. What happens? Suppose let's take the example of leach factory only. Suppose leach factory comes in a village and wants to have contract with all the farmers of the village, and so the factory is going to mm, not going to enter with contracts, not going to talk with each of the farmers of the village. What happens, that there will be a leader who is representing all the farmers of the village to the factory, and on the behalf of all the farmers of the village, the leader is going to engage in a contract with the factory. And it becomes also feasible during the time of dispute. Suppose there is a dispute between the particular village and that factory, then that leader can also represent particular village and particular farmers in the front of conciliation board or in the front of SDM or in the front of collector. So to simplify the very process, the provision of aggregator and farm produce organization has been made. Okay, is it everything clear for this bill?
I have a very small doubt,
Yeah,
a very, very small doubt. Maybe I didn't understand.
yeah,
Uh, you said the prefix plus flexibility, right? That price fixing mechanism. So you
yeah,
said if the market price increases,
yeah,
uh, the company can also increase the price. But
yeah,
why would a company do that? Isn't that a loss for the company?
yeah. The law has been very clear. It's mentioned in the bill itself that there should be a clause of flexibility. That suppose the same condition, if the price becomes 35 at the time of harvest, then there should be a clause of flexibility, because then because the government uh, doesn't want the farmers to face problem. That's why they have added the clause of flexibility, so that if the if the price increases in the market, then the company have to increase the price proportionately to the market. And it has the also it also has the option to to put a price which is more than the market price.
No,
Okay,
but my question is, why would a company do that?
because
That
it's
would be
mentioned in the
lost
law.
to. Okay, got it.
Because if the company has to do business in India and has to do the contact farming thing, because see, the main thing is that why company would want to enter in contracts with farmers only, because the company don't want to go to the market. They, because a company wants to know what all is its stake. They want to know what all the potatoes they are getting from the farmers. So they have to set a particular requirement, that this is the requirement which you all are going to fulfill. Okay, so that's why they are going to enter in the contract, and that's why they are preferring to have a flexibility clause in the this case.
Okay, okay,
Okay,
thank you.
so moving on to the next bill. The next bill is an amendment, which is amendment of the Principal Act. The Principal Act is the Essential Commodities Act of 1955. So the Essential Commodities Act of 1955 has mentioned that there will be a criminal case on the person who has stored the commodities above the limit mentioned in the act, and the burden of proof will be on the accused. So simplifying it, there will be some fruits, some crops will be mentioned in the Essential Commodities Act 1955, and the mentioned crops and fruits have a prescribed limit in the front of them, and no person can store that particular crop and fruit or vegetable more than that prescribed limit. And if any person then they have to, then there will be a criminal case on that person who has stored the commodities, and also the burden of proof will be on the accused. So it's not only on the crops but also on the fruits and vegetables. So fruits and vegetables also are included in that particular list, which is in the Essential Commodities Act 1955. Now the government did an amendment and amended the bill. So what they did now, that they mentioned that the regulation mentioned in the Essential Commodities Act 1955 will only be applicable in extraordinary circumstances, and the circumstances are such as war, famine, natural calamity, price rise. Or what kind of price rise? In horticulture, they have separated the items. In horticulture, such as in fruits, vegetables, and flowers, if the retail price enhanced by 100% in 1 year, they have all the data, that what is the market price in 2019 and what is the market price in 2020 and what is the market price in 2021. So if the retail price enhanced by 100% in 1 year, or in non-perishable items such as in rice, wheat, oilseeds, if the retail price enhanced by 50% in 1 year, then the Principal Act, that the Essential Commodities Act, comes into play. In Essential Commodities Act of 1955 comes into play. Till that time, the people can store more than the prescribed limit. And there is in such cases, suppose there is an extraordinary circumstance, or suppose the price have risen, and then also there are two exceptions. Suppose there is the first exception is of food processing unit, and the second is of exporting company. So what happens, suppose there is a food processing unit and it has a particular instant capacity of 50,000 kg of potatoes. Then and the prescribed limit of storing potato is only of, suppose it's only of 300 kg. Then if the instant company of any food processing unit is more than the prescribed limit, then also they can the store the commodity up to the instant capacity. They can't store more than that, but they can store up to the instant capacity. Second is of export demand. Suppose there is a exporting company which exports rice, and it has a particular export demand of 50,000 kg. Then they can store, for exporting they can store up to the export demand which they are having, and but they can't store more than that. Okay, is there any doubt in this bill?
No, sir.
Okay.
So,
So
sir, it also applies to fruits, vegetables, crops, and all types of essential commodities, right?
yeah, basically, the farmers are only protesting for crops. So everybody has the general idea that agricultural harvest is only about crops, agricultural commodities are only about crops. But in all the three bills, the agricultural commodities includes fruits, vegetables, and milk also, even milk also. Okay.
Okay.
Okay. So moving on to the Supreme Court's decision, because the matter went to Supreme Court and Supreme Court has given 7 steps. So the first step of Supreme Court is that it state the farms law, and the second step is that everybody is protesting for the MSP system, though there's nowhere mentioned in the bill that MSP system will be removed. Maybe it can be indirectly. Maybe there is an indirect issue that in the future it can be removed, or by the effect of the bill it can be removed. But there's nowhere in the bill that the MSP system is going to be removed. Then also, Supreme Court has mentioned very clearly that MSP system as it existed before the enactment must be continued, and it's a duty for the government. No. Third point, that no farmer must be dispossessed or deprived of his title. Of his title means of his land as a result of any action taken under the law. And it's very clear in the second bill only that the factories can't acquire land from the farmers because they are having contracts only for the harvested crops. So they can't acquire land from the farm. But Supreme Court has also made it very clear. Now, coming to the fourth point, Supreme Court has appointed a committee comprising of Bhupinder Singh Maan, Pramod Kumar Joshi, Ashok Gulati, Anil Ghanwant, and constituted it for the purpose of listening to the grievances of farmers relating to the farm laws and views of the government to make recommendations. So they have appointed committee of these 4 members, but what happened that Bhupinder Singh Maan is a farmer leader and he has recused from the committee. There's his own personal reason. He says that many reasons in front of media, but the main thing is that he's recused from the committee. Currently, the status is that he's not in the committee. He recused himself from the committee, but he's saying I am with the farmers and I am not in the committee. Okay, so for your consideration, it's very clear that committee initial committee has Bhupinder Singh Maan, but currently Bhupinder Singh Maan is not in the committee. Now, coming to the fifth point, the committee shall be provided a place at Delhi and government to bear its expenses to give its secretarial assistance. Coming to the sixth point, the representatives of all the farmers' bodies, whether they are holding a protest or not, and whether they support or oppose the law, shall participate in the deliberations of the committee and put forth their viewpoints. So, related to this point, what happens that many people are saying that farmers from Haryana, from Western UP, and from Rajasthan and from Punjab are protesting. So the issue is also that why not the farmers of whole country is protesting. So the main thing is that there are many farmer groups there are many farm produce organizations already existing in our country, and they have their own leaders. Some leaders are with farms law, some leaders are against farms law. But that's why Supreme Court mentioned, stated clearly that it doesn't matter that whether you are against farm law or whether you are in support of farm law. If you are a leader, if you are representing farmer bodies, then you have to discuss your views to the committee, and you have to put forth your viewpoint so that a final conclusion has been made. Now, coming to the last point is that the committee should file the report within 2 months before the Supreme Court, and first sitting to be held within 10 days. And then you all know that on 26th January, what happened, there's a protest. In protest, they have broken the law. So after that the committee work is stopped, and it, we will see further what's going to happen. Okay, so is it very clear, or should I move?
Yes, so one thing, I got network problem during you were explaining the MSP system. So can you please repeat that one point?
So there are many people who have if you watch the news, there are many people who are protesting for the MSP system. They think that MSP system will be removed. MSP is the minimum support price which the government gives for only 3 to 4 crops such as wheat, rice, and cotton and sugarcane. So uh, so MSP is a minimum support price, and the farmers, the people think that it's going to be removed by the bill. But the government is very clear. Nowhere in the act is mentioned, in the bill is mentioned that they are going to remove the MSP. It can be done indirectly, but nowhere in the act. But act doesn't mentions it. And Supreme Court also made it very clear that MSP system as it existed before the enactment must be continued. So now it's a duty on the government to continue the MSP system. Okay.
Okay, sir.
So now there will be a set of questions, and first you guys will do it, and then I will explain if there is any problem. Okay. So this is the passage, and the first question related to the passage. So what is the time? So it's 7:48, and take 2-3 minutes to solve this first question and mention your answer. Then we will discuss. I hope you all are doing it.
Yes, sir.
Okay. So have you all completed doing it?
Sir, I'm doing it once again.
Okay. So what about others? Others, please mention your answer in the chat box. Then we will start discussing this. It will be helpful for you guys if you mention the answer, because then only you will get to know that what is the mistake you guys are making, because I will discuss each and every option. So it will be better if you guys if you all mention your answer. So should I discuss it? I think I should discuss it because it's 4 minutes now. And
Yes, sir. We have given our answers.
okay, so the passage starts with the Article 245, and it states that Parliament may make law for whole or any part of India, and the legislature of a state may make laws for whole or any part of the state, because the legislature of a state is responsible for the state. Now, it again states Article 246, which we have discussed. And this shows, because most of the time what happens, that article comes in the passage, and that's why it's important for for all of you to remember certain important articles of the parliament of the constitution, so that you are not going to face any problem while reading the passage. So Article 246, as we have already discussed, it states says Parliament has the authority to make laws enumerated in List 1 or the Union List in the 7th Schedule. The states have similar authority to make laws in List 2nd or the State List, and both have the authority to in respect to the List 3 or the concurrent list. We have discussed this briefly. So coming next, it's Article 254 of the Indian Constitution deals with the doctrine of repugnancy. What repugnancy is? It's mentioned that repugnancy here is a legal term that means inconsistency between two or more parts of a legal instrument. No, they're discussing Article 254.1 and a summary of Supreme Court judgment in M. Karunanidhi versus Union of India, where it's mentioned that where the provisions of a central act and a state act in the concurrent list are fully inconsistent and absolutely irreconcilable, the central act will prevail and the state act will become void in view of repugnancy. So there should be the first thing is that the topic should be in concurrent list. The second thing is that if the both state and center has made the law, then those law should be fully inconsistent and absolutely irreconcilable. And what happens, what is the result of it, that the central act will prevail, and the other result of it is that the state act will become void. Okay, moving on to the question. In this question, the state of Punjab has passed one law, Essential Commodities Act 1955, provisions related to agriculture. The topic agriculture is there in the state list. So by the virtue of Article 246, it becomes clear that if the topic is in the state list, then state has the right to make law on that particular topic. Now, central government has opposed the act on various media platforms and claimed that the act is not good for the state and it's not a good decision of state government to pass the act. Central government can obviously do that, and central government usually do this. If the party in center and the party in state is different, then usually it's the usual practice. Central government always criticize the law passed by the state because the party is different, and it's the usual practice that state criticizes the law passed by central government. Then the question is that is the act passed by central government valid or not? Moving on to the first option, let's check it. Not valid. Option first say that it's not valid because state should have passed the law with the permission of central government. No, this is wrong option, because if the topic is in the state list, then by the virtue of Article 246, state has the right. Its state can make law independently without the permission of central government. Without even informing central government, state can pass that particular law. So this option is wrong. Moving on to the option B. Option B states that act passed by state is valid as state has the right to pass the act because it gets power for the same from state list. So this answer sounds correct, but let's check other answers also. The other C option is central government will repudiate the act. Okay, but why? Why central government is going to repudiate the act? This must be a question in front of us. So central government can't do this because we have already briefly discussed about Article 246, which I'm stating it again. And the Article 246 states that if there is any topic in the state list, then state independently has the power to make laws on that particular topic. It doesn't have any duty to inform central government. So central government can't repudiate that particular act. Okay. Now coming to the
Sorry, I have a doubt.
yeah.
I thought agriculture was part of the concurrent list.
Okay, we will discuss this also. I have seen your answer. You Hari or Harina?
Yes, sir.
Yeah, we will discuss your point also. Okay. Now coming to the D option. D option is that the option states that act is not valid and state is a part of India and thus only government of India has the power to pass act. This is very redundant because if if anyone has read Article 246, then it very clearly mentioned that states have their own topic in the state list, on which, and Article 245 also states that state can make law for for the whole part of that state. If the topic is in the state list, then state can make law on that. Now, the Harish question is that he thought that the topic is of agriculture. So, what the CLAT consortium has suggested, that you shouldn't be having the prior knowledge of anything. We have discussed farms law, but then also, when at the time when you are appearing for the exam and solving this kind of question, suppose it's related to farms law only, then don't think it's the same farm law which we have discussed. The law can be same, but the means the article 246 will be same, article 254 will be same, but the things which are mentioned in the passage, it's just a story. You don't have to make your mind already that it's the same farm law, and topic agriculture is there in the concurrent list entry number 33. We have read it, it's very good that we have read it, but then also, if it's not mentioned in the principle, we don't have to apply our prior knowledge. We have discussed article 245, 246, 254, so that we can easily grasp the passage. This is the whole purpose of discussing the farms law. Okay, Hari?
Yes, sir.
Okay. So don't apply any prior knowledge unless and until it's given in the passage. So should we move to the next question?
Yes, sir.
Okay. So yeah, take 2-3 minutes, solve this question also. So have you all completed doing it? Because the passage is same, the question is different. So mention your answer, guys, here. Till now, only Hari has mentioned his answer. So I am expecting others also to mention the answer. You all have to be fast. Because the path is same, the question is different. Just do it fastly. Okay, so let's start discussing it. So the passage same. It contains Article 245, Article 246, and Article 254. And then 254 Clause 1, as summarized in Supreme Court's decision M. Karunanidhi versus Union of India. We all have read it. and if there is a requirement, then we will again move to the passage. Okay, so let's come to the question. Question indicates that after this incident, Government of India by an amendment included the topic of agriculture in the entry 33 of concurrent list. In the year 1962, state of Punjab has made certain laws on the topic of agriculture and named it Agricultural Reforms Act. So, government state of Punjab has made law after the topic is included in the entry 33 of concurrent list. Here, Hari, here you have to check that here it's given in the passage itself that the now the topic agriculture is in the entry 33 of concurrent list.
Yes,
Now,
sir.
okay, so now in the year 1962, state of Punjab has made certain laws on the topic of agriculture and named it Agricultural Reforms Act 1962. Then simultaneously, central government also passed a law on the topic agriculture and named it Farms Law 1962. The names are different, but the laws are fully inconsistent and absolutely irreconcilable with respect to the law passed by the central government is absolutely irreconcilable with respect to Agricultural Reforms Act 1962, which is passed by the state of Punjab. So the question asks which of the mentioned acts is considered to be valid. Um, the answers which you all have given is B and C. So I think there's a confusion between B and C. So let's check from the starting from the A option itself. A option suggests that Agricultural Reforms Act 1962 is valid as it was passed first. It's redundant, completely redundant. It doesn't matter which law is passed first. No, this is wrong. So coming to the option B. Option B suggests that Farms Law 1962 is valid because it will prevail as an effect of Article 254.1. So for this, we have to know what is Article 254.1, which is summarized in M. Karunanidhi versus Union of India, and it states that if there is any topic in the concurrent list on, and we know what is concurrent list, a state and central government both can make a law on the topic on the subject which is mentioned in the concurrent list. And suppose they both have made law and the laws are fully inconsistent and absolutely irreconcilable, then what's going to happen as per the passage that the central act will prevail and the state act will become void in the view of the repugnancy. Okay, so this answer seems to be correct because the Farms Law 1962 is valid because it will prevail as an effect of Article 254.1. It suggests the same thing which is mentioned in the passage. Now, as you all have also, one person has also mentioned the answer C. Let's check it also. Option C states that Agricultural Reforms Act 1962 is valid as an effect of Article 245 and Article 246. Okay, but what we have discussed, one point which we have discussed is missing here. While discussing Article 254, we have discussed that if both the laws that the law for are passed by central government and passed by state government are fully inconsistent and absolutely irreconcilable, then first thing is that central act or the law passed by central will prevail. And the second most important thing is that the state's law will become void. It becomes void. Though state has the power under Article 245 to make any law for whole or any part of the state, but that power is only for the topics which are there in the state list, not for the topic which are there in the concurrent list. So that's why option C is wrong. Okay, Gargi. So option C, you know the reason why it's wrong?
Yes, sir.
Okay. So moving on to the D option. D option suggests that both of the law are invalid as they are inconsistent and government should make some new laws. So these suggestions are not invited here in the paper. So if any option suggests anything, then it's a high probability that the option is wrong. But this suggestion is also not in coherence with the passage, so it's completely wrong. Okay, so should we move to the next question?
Yes, sir.
Okay, this is the last question. and the passage is different, the question is different. Read it carefully, take 3 minutes, only 2-3 minutes, and submit your answer. We have already discussed ordinance as per Article 123. So I don't think that you should take so much time in solving this question. It's an easy one. So okay, so let's start discussing this question also. This is the last question. So starting from the passage. Passage is fully of ordinance. It starts from a general definition of ordinance. Ordinances are primarily just laws that are passed by the President of India in times of need and urgency to combat unforeseen circumstances like the current pandemic. So these ordinances have the same effect as that of an act of parliament. They enable the government to take immediate legislative action in desperate time. This is the general explanation. Now moving on to the article, because articles gives a great and it covers each and everything. So articles are very important while reading the passage. You can read other part in a view, in a glimpse, but just focus on the articles. Articles are the main part of the passage. They are the soul of the passage and they will give you the result. So Article 123 gives power to the president to promulgate ordinance when parliament is not in session. We have already discussed that the first condition is that the parliament has the right to promulgate the ordinance, but the first condition and the first criteria is fulfilled that when the parliament is not in session. Second, this ordinance will have the same force and effect as that of an law. Okay. And shall be laid before both houses of parliament. It should be laid before both houses of the parliament within 6 weeks. Means the passage states that and shall cease to operate at the expiration of 6 weeks from the. Okay, someone's unmute your mic. Okay, let's let's start. So and shall be laid before both house of parliament and shall cease to operate at the expiration of 6 weeks from the reassemble of parliament, if not passed by both houses of the parliament. We have discussed that if the ordinance is not passed by both house of the parliament within 6 weeks, then it will cease to operate. Means its effect will be over. Okay. However, even though there are distinct powers and duties assigned to all three, the power of executive and legislative overlaps on Article 123 of the Constitution of India. Article 123 of the Constitution of India provides the President of the nation with the power to promulgate laws in an emergency situation. Okay, the situation should be emergency. Of the parliament is in recess, but the parliament session is not going on that time. However, despite these laws having the same force as in any legislative passed laws, these ordinances are temporary in nature. Okay, so these ordinances are temporary in nature. They have to be passed within 6 weeks when the parliament comes into session. After parliament comes into session, within 6 weeks, the parliament, both houses, have to pass the ordinance, and then it will become a permanent law. Okay, moving on to the question. The question is that on 12th April 2016, when Parliament not in session, first criteria fulfilled. The President of India passed an ordinance, which is Security of Agricultural Producers 2016, for a particular purpose, which is security price of harvested crops. Okay. As per the provision of this ordinance, farmers has to sell their first harvest in APMC, and if some other shopkeeper buys the harvest, then he will be punished. Okay. This is the provision of this particular ordinance passed by President. On 18th July 2016, session of Parliament started and got ended on 18th of September 2016. But the ordinance was not passed. The main matter is here that the ordinance was not passed. Till in the whole duration of Parliament session, the ordinance was not passed. So means the 6 weeks was expired. So on 17th of September, one farmer, Savita, sold her first harvest to one of the shops in her village. 17th of September. Okay. And the didn't sell in APMC. The police caught the shopkeeper as per the provisions of Security of Agricultural Producers 2016. Whether the decision of police is correct or not. Okay. Now coming to the first option. First option is that it's legal for the police to arrest the shopkeeper as per the provisions of ordinance. Okay. It has been legal for the police to arrest the shopkeeper if the ordinance was effective that time when the offense was committed. If the first of all, the offense would have been an offense if the ordinance was effective, but ordinance was not effective at that particular time when the Savita sold her first harvest to the shopkeeper. So when if the law is not effective, then nobody can force you to comply to the provisions of the law which is not effective. So it's not legal for the police to arrest the shopkeeper. The option A is wrong. Coming to option B, police can't arrest the shopkeeper as the ordinance has ceased to operate. Okay, this seems correct. Coming to the C option. C option suggests that police should arrest such shopkeepers who try to exploit poor farmers, so the step of police is valid. As I already mentioned, be far from these kind of suggestions unless and until it's matching with the passage. It's not matching with the passage. None of the places it's suggested that police should arrest such shopkeepers who try to exploit poor farmers. We are going to apply legal principles, not the moral principles. So this is wrong option. Coming to the option D. Option D suggests that police should have knowledge about the new laws and ordinance passed. So the decision is wrong. Okay, so they should have knowledge, but they are not having knowledge, and we don't have any law in the passage which says which states that police should have the knowledge and shouldn't have the knowledge. So this is also a suggestion. So it's also not matching with the passage. So this is wrong. So option B is the correct one. Okay, is it okay with everyone?
Yes, sir.
Okay, so this is the last part of the slide. If you have any doubt, just take a look of it, and then we can leave the meeting. And if there is any suggestion from you guys, if you think that that any part I have missed and a part which you guys want to include, then you can inform me about that particular thing.
No, sir, it was very helpful.
Okay.
Yeah, thank you, Yash, for the session. Everyone, please note down this. You can take a screenshot if you want to refer to the answers. I think we are done with the meeting now, and all of you will end the meeting now. Thanks a ton, Yash.
Okay. Thank you.
Yeah. Okay.
Thank you, sir.
Thank you.
Thank you.